we're going to talk about some basic information about child support. There are different ways to calculate it, and there are different guidelines, but a lot of people don't understand sort of the basic premise of child support. The basic premise of child support is that, much like with spouses, parents are required to financially support their children. That's that duty that we have, and we have that when parentage is established. We can obviously establish the parentage of a mother at birth, and child support can be established in all the different ways we talked about paternity establishment previous to the course, or previous to this this lecture. But support really talks about money from one parent to the other. Okay? And so there are some very specific statutes about this, and every single state, because of federal law, has guidelines. These guidelines are numerical calculations, and most states, in fact, I don't know of any that don't, have calculators that you plug in specific data, and it takes the income of the parents and does some calculations with it, and out pops a specific number. And I don't want to belabor that, because you're going to be doing that for your assignment that's due Wednesday. Some of you already have. I want to explain sort of substantively why we do that and give you a couple of tips, pointers. Okay. So as your book talks about, there are two main ways that we calculate support. One is a straight percentage. I'm not going to talk too much about that. Why? It's super easy. You look at income, you take a percentage of it, that's it. And very few states do it. So the other way that we look at child support is this expenditure model that we use the guidelines for, and most states do it this way. You need to know a couple of asides. First, if paternity is established on a child later in that child's life, let's say the child is 2, in some states, the custodial parent can ask for back child support. So you do not know that a child exists. Usually the mother, because the mother's there when the child is born, does not tell the father or cannot find the father, and in some states can ask for back child support from the date of the child's birth, and can ask for maternity expenses. This can be a significant financial burden on the other parent, and you should know about it. In addition, the way child support works is that typically the support is calculated based on income, based on the number of days you have the child, and based on how many children you have from previous relationships. So it's a pretty difficult calculation. And I will tell you right off the bat, people who've been doing this for a number of years, you can take the same 2 attorneys, give them the same information and the set of guidelines, and they will have different calculations. It is possible to go to court where the petitioner has one amount, the respondent has another amount, and the judge has a third amount. And so very frequently, the guidelines are supposed to make it easier, but they're not. They're not easy to fill out. They are difficult. So if you are struggling with a specific amount, do not worry about that. I am not looking for a specific amount on the assignment number 2 in this course. So understand that it is difficult for everyone, and it isn't just students that struggle with it. Okay. So the concept of child support is that it takes a certain amount of money to raise a child. It takes certain things a child needs. And we assume that the person who has custody of that child is providing for that child. And so the non-custodial parent is the person that's going to chip in. And so when we say that support is money that goes from one parent to another, it's to support that child. The money flows from the parent with less custody to the parent with more custody. So the amount of custody is a major determination as to the child support amount. So is it possible, and we talked about this in the last video, is it possible that someone may want to modify custody so that support is modified? Yes. The more custody you have of a child, the less you pay, or the less you're responsible for. And in most states, that reduction in your child support obligation does not happen with visitation. It does not happen until you have overnight custody. And so let's take Indiana, for example. The reduction in custody does not happen until the less custodial parent has at least 2 nights per week. In Indiana, the parenting time guidelines start on like Wednesdays and Saturdays is how, let's say the father would start with custody. And so it isn't until that father has custody 2 nights a week that child support obligation would go down. Many people assume that if we have a true 50-50 custody arrangement, so we have a 2-3-2, 3-2-3 situation where mom has the kid for 2 days, dad has the kid for 3 days, mom has the kid for the other 2 days, and it just goes back and forth. And so it's true 50-50, that there is no child custody, or there is no child support. That is not true, because child support is based not only on custody, but it is also based on the income of the parties and whether the parties have other kids that they are supporting outside of the relationship, outside of the kids they have with each other. Here's what I mean. So let's say you have a true 50-50 situation and mom and dad both have 50-50 custody. Because they have custody half the time, why do we need to send support? The only way in most states where we have 50-50 custody and therefore no child support is if the parties both make the same income and don't have other extraordinary expenses or other children to support. So if we make the same income and we have the kid the same amount of time, then no, we're not going to pay child support. Also remember that this is when it's a fight. Can people agree not to pay child support? Absolutely. We have all kinds of situations where, in fact, I have friends of mine where I look at the situation and I'm like, the husband, the father, there is no child support because they've agreed to work everything out. They have the kid 50-50, but the father makes a whole lot less than the mother and could be getting child support. But because it's working for their family, he has chosen not to do that. And so they just support the kid when they have the kid, and there's no child support that goes back and forth. So we can agree not to do this. And there's all kinds of situations where people don't take someone to court for support, or they agree on something that is outside of these guidelines. It's not just based on who has custody and how much, but it's also based on the income of the parties. And that income is also impacted by whether or not there are any other outstanding child support judgments. So do I have another child that I'm supporting? My support for this child may be reduced because I'm already supporting another. So if you want to talk about how that works, that means children later in line, and you can look at the Wisconsin example in your textbook for the percentage. The percentage per child goes down with each subsequent child to the point where I think the Wisconsin example was like the 5th child only gets like 4% of the income, whereas the first one got something like 17. So after-born children end up getting less because we already have obligations to the first ones, and that doesn't seem fair to some people. So that's how it works. Okay, so understanding that we can contract around this, and we can contract around this. We don't ever have to go to court. We can go to court and get a judgment and agree not to enforce it. There's a bunch of different things that can happen. So that's how it's established. We look at these guidelines and we put in factors like who has the child when, what is their income, are there any other obligations? And the guidelines when they are calculated, they come out with a support amount. And sometimes they come out with just the amount that the payor is going to pay. Sometimes they come out with an amount that based on the party's income, this is the amount that that should be set aside for childcare, and because the payor has a higher income by 10%, they're going to pay 10% more of that amount to the payee. And so it's a mathematical calculation. And once those guidelines are calculated, you go in front of a judge, and the judge typically may deviate from those guidelines for reasons they feel are appropriate. Sometimes we don't feel that those reasons are appropriate. Usually if they do deviate from the guidelines, they say why, and they have some sort of reason as to why. And that's what the support order is. In making those calculations, the guidelines can also do something called impute income. So, it used to be that someone who did not want to pay child support, because as you can imagine, this can be a very touchy subject, and people don't want to give money to their exes. They just don't. If they wanted to give money to their exes, maybe they wouldn't be an ex anymore. And so we have people who try to get out of their child support obligations. And in doing so, sometimes people quit a job. Well, if I'm not working, then I can't pay support. I don't have any income. Typically, states don't allow that. And so they look at something called imputed income. And so if someone is not working, and they're not working by choice, the court can impute a reasonable income to them. Typically that starts at minimum wage, but I have a law degree. I've been teaching for 10 years. I've been a lawyer for 20. No court is going to impute just minimum wage to me if I decide to stop working so that I can avoid, for any reason, and then use it to avoid child support obligations. Court is going to impute an income to me. So even if I don't have any, if I am not working, then the court may impute that income to me in calculating this guideline. Now, if someone is disabled and cannot work, then we're not going to impute an income to them. This is just for people who have lost a job, have trouble keeping jobs, or are specifically not working in order to get out of child support. And the court is not going to do that underneath the guidelines. So, we will at some point have a lecture about children in the state, and we will revisit this topic again as well. All of this discussion so far has centered on two people who are parents of children who are either negotiating child support or fighting about child support in court. That is not always how it happens. In fact, people who get along really well and agree either not to have child support or agree what child support will be don't ever have to go through any of this. But very frequently we will see child support enforcement done through the prosecutor's office in a particular county, and here's how that works. For children, not for spouses, the state can get and pay child support. Here's how that works. So let's say we have a woman in poverty who has a child, and there's no child support order because at the time that the child was born, she either did not know or did not state who the father was, and is not getting support. And so she goes to sign up for public assistance benefits, whether it's Section 8 or any sort of other benefits for that child. And she can get paid benefits from the state, whether it's TANF or whatever benefits that she can get from the state. And the state, because they are paying her benefits, is going to seek reimbursement. And they do that by finding out who the father is and getting a paternity suit and a child support suit against them. And so sometimes that can benefit the state. If the child is taken away completely, so let's say DCS is involved and a child is taken away from the parents, DCS can get a support judgment from those parents to support the child while they're in DCS custody. But let's take the first example. So we have someone going to get benefits, and the state is going to file a support action on their behalf. It is related to the benefits that they have sought. Additionally, if someone wants to seek child support enforcement without seeking benefits, they can also do that through the prosecutor's Office of Child Support Enforcement. So whether it's because they've sought benefits or they just are seeking help for child support enforcement, child support establishment, the prosecutor's office in most counties can do that. It's a civil branch. Very often prosecutors' offices are organized with the civil forfeiture attorneys and the child support attorneys sort of in a different wing because they do all of this civil stuff on behalf of the prosecutor's office. So let's say we've got a case like that where the mother of a child is seeking child support enforcement through the prosecutor's office. The prosecutor's office assists her in filing a child support claim against the father, and perhaps paternity needs to be established as well. Paternity can happen in the course of that child support enforcement case. So they file child support enforcement. The father says, well, I've not been established, a putative father. And then we find out with paternity tests either that they are or are not the father, and then the child support case goes forward. We do the guidelines, all of that. So let's say that happens. Child support, whether it is established by a judge, whether it's agreed upon by the parties, or whether it's sought by the prosecutor's office, it all can be memorialized in a court order. If someone stops paying, they are in contempt of court. And contempt can come with a variety of different things. You can be jailed, you can get an arrearage order against you, but there are sanctions that can happen if you stop following a child support order and you stop paying. Your wages can be garnished, for instance, and sometimes that even happens before you stop paying, like right when the support can be entered, when the order is entered, maybe there are arrearages, because if someone files in July, let's say, and it takes until October to establish paternity, there's an arrearage amount for at least that portion, and wages might be garnished as a result of that. So let's say we've gone through court and there's a child support order and the payor stops paying. They have an arrearage. Over a certain amount, I'm sorry, this is terrible handwriting, but if they stop paying pursuant to a court order that goes on long enough, and that the arrearage gets large enough, and we're talking tens of thousands of dollars. I think in Indiana, the last I looked, $10,000 was either a misdemeanor or a low-level felony. $25,000 was a higher-level felony. It can become a crime. So child support enforcement can go from civil to criminal if someone willingly refuses to pay their child support. Now, this doesn't include people who lose jobs or get sick or get disabled. Certainly in a pandemic, it's much less likely that we're going to hold people responsible. And as a former child support prosecutor, I was never in the enforcement division, but as a felony prosecutor, I had felony arrearage cases come to me pretty frequently. Courts are reluctant to put people in jail over this, and they are because, as we talked about in a discussion board, it defeats the purpose. If I put you in jail because you didn't pay, what are you going to do? You're going to lose your job. So some of this defeats the purpose, but that's how support cases go from civil enforcement to criminal enforcement. It's a willful lack of pay over a significant period of time. The amount is going to be statutory and determine statutorily determine what the sanctions are. Okay, I'm going to pause right here. We're going to come back with modifications and other kinds of support and support past majority.